Let's journey through the rules and regulations surrounding repairs and maintenance for your rental units. At Your Home Imagined, we pride ourselves on being experts in property management and keeping you up to date on important topics. Today, we are talking regulations around repairs. Ultimately, in the state of California, property owners are legally responsible for their property's condition. This means landlords must repair defects and failures in a rental unit to comply with state and local building and health codes. However, the landlord is not responsible for repairing damages that were caused by tenants or the tenant's family, guests, or pets. A rental unit may be considered uninhabitable if any of the following conditions apply: broken windows, exterior water leaks or interior mold, lack of running hot or cold water, and sewage disposal system problems, lacking source of heat, no utilities, unsafe electrical systems, operable deadbolt locks at all main entry doors, working smoke detectors and carbon monoxide sensors. Also need a mailbox for each unit. Habitability is not violated just because the rental unit is not in perfect condition or not aesthetically pleasing. Tenants are required by law to take responsible care of the home that they are renting. This includes common areas, any hallways, yards. Tenants are responsible for repairing all damages that are caused by them or their guests and pets. Examples of tenant responsibilities could be large tears in carpets, stains that cannot be cleaned, drawing on walls, holes on walls larger than a dime or a large number of holes, which is relative, pet damage, including any chew marks, digging in the yard, and fence damage, foreign objects in the plumbing, and overloading electrical circuits. Disposing of trash and garbage. They're also responsible for keeping the property clean and sanitary, and they must notify management or property owners whenever there's an issue. Less serious repairs are sometimes included in the rental agreement. Examples of landscaping and appliances that may be included with the rentals. Property owners and tenants sometimes make agreements that the tenant will perform some of these repairs and maintenance. Regardless of these agreements, though, the property owner is ultimately responsible for maintaining their property, as required by state and local housing codes. If a tenant agrees to make repairs, then the tenant must intend and be able to make these necessary repairs. Otherwise, this is considered a breach of contract. Property owners should put in place a process for tenants to notify them of repairs needed included in the lease agreement, including a written record of all repair notifications, the time repairs were completed, and the ability to include photos. It's in the owner's best interest to keep their property in good condition and stay up to date with maintenance. For repairs that require urgent attention, the tenants should contact the manager or owner as soon as possible by calling or texting. Repairs requiring urgent attention could be water intrusion, electrical problems, wind damage, and other emergencies. Property owners, managers, and maintenance people may enter the rental unit, if necessary, only when agreed to make repairs. If the tenant has not specifically scheduled a time, the landlord must provide at least 24-hour notice in advance of entry in writing. If an owner refuses to make repairs, tenants have a couple of options. The first option is called repair and deduct, where the tenant takes upon themselves to repair an issue and then deducts it from their rent as reimbursement. Repair must be less than 1 month's rent. The second option is abandonment remedy, where the tenant chooses to move out due to repairs needed. The third is to withhold rent, where the tenant refuses to pay rent until repairs are completed, at which time the rent could be due in full. The basic requirements and steps for remedy are as follows. The defects must be serious and directly related to the tenant's health and safety. A tenant cannot use remedy more than twice in a 12-month period. The tenant cannot be the cause of the issue. Tenants must inform the landlord of the repairs that are required. The tenant must give the landlord a reasonable period of time to make the needed repairs before undertaking any remedy. The law considers 30 days to be a reasonable amount of time. Shorter periods of time can be considered reasonable depending on the situation. More serious situations, reasonable time is considered 2 days. That's assuming a qualified repair person is available. If a property owner does not make repairs within the reasonable time and the tenant uses a remedy, it is highly recommended, but not required, for them to notify the property owner in writing of the process that is taken, all notification to the owners, and exact repairs needed, and the details of the remedy. If the tenant repairs and deducts, there should be a detailed receipt for all expenses and hours worked. There are risks to using these remedies, as it may be decided that the repairs were not serious enough to justify the remedy. If the tenant deducts money or moves out without giving the owner proper advance notice or a reasonable period of time, courts can order the tenant to pay in full, even though the tenant paid for the repairs. Tenants should always document the defective conditions with photographs or videos and keep copies of all notices to the property owner, and check with legal aid organizations, lawyers, housing clinics, or tenant programs to help determine if this is the right remedy. Examples of defects serious enough for withholding rent are collapsed ceilings, mice, fleas, and cockroach infestations, lack of heat, lack of water, plumbing blockages, exposed and faulty wiring, illegal installation or dangerous stoves or other gas appliances. If any of this goes before a court, it is helpful to have photographs and videos of the required repairs, witnesses, and copy of notices informing the property owner or management. A report from local health and building officials is also a good idea. Whenever a tenant is having to use a remedy to have the repairs completed, you should always include a certified letter to the property owner or manager, or an in-person signed and dated. This goes a long way if you have to go to court. If tenants refuse access to complete repairs, a property owner must also document as much as possible. You should keep notes of each conversation, including dates and times and who called who. It's important to note that neither the tenant nor the landlord can record a telephone conversation without the other party's permission. As a property owner who is given notice of entry to a unit to make repairs and you do not have access, you should leave a timestamp note and take a timestamp picture of this note on the property. We hope this information has provided you with a deeper understanding of repairs and maintenance responsibilities as an owner of a rental property. At Your Home Imagined, we take pride in our expertise and commitment to ensuring smooth property management experience for landlords and tenants alike. Should you require professional property management services, we would be thrilled to assist you in maintaining your rental property, navigating repairs, and providing exceptional service to your tenants. Together, let's create a rental experience that exceeds expectations and fosters positive relationships between property owners and tenants. May your cash flow always stay positive. Please like, subscribe, and comment if you'd like any further topics discussed.